Now, our next session is Trade Secrets and Trademark Protection in the Age of AI, Challenges and Future. To moderate this session, I would like to invite Jyoti Kumari, patent attorney and founder, Lex Innovation India. Okay, I will call her. And, okay, that's fine, we will call her. And, and I would like to invite Muhammad Talal Farrukh Irfan Khan, Senior Associate, United Trademark and Patent Services, UAE. Please welcome them on stage. Yeah, I will. If you want, you can start.
Okay. Hi, everyone. My name is Talal Khan. I am a IP lawyer here in the UAE. Our panel was actually supposed to be at 2, but I think we've just been pulled up, so I think that's why Jyoti is not here. Let's see. Okay. So while we wait for Jyoti, I think I might as well just start. So like I said, I'm an IP attorney here. I'm dual qualified in Canada and Pakistan. Just to tell you a little bit about the firm. So we are a IP boutique with 16 offices across the region. I'm based here in Dubai, but also work for our Pakistan office, and we do all sorts of IP, trademarks, patents, data privacy, anti-counterfeiting. Um, so we've had a couple of really good speakers already talking about AI in general. And we've also talked about data protection and trade secrets a little bit as well. So our presentation is probably going to talk a little bit about those similar topics as well. Um, but I just wanted to give a brief framework about what the legal framework in the UAE is at the moment. So we don't have a universal definition pretty much anywhere in the world, but some countries recognize trade secrets as a protectable IP, others do not. So we don't have a federal legislation here in the UAE, but some examples you have in the US. Um, the US has the Defend Trade Secrets Act, which is a federal law, and then they have a state equivalent for the Uniform Trade Secrets Act, which has a bit of a criminal element. So you have IP, which is a commercial law, but also a criminal element as well. The European Union has its own directive, which one of the previous speakers, Victoria, was talking about. Um, but again, everybody has a different definition of what they categorize as a trade secret. The World Intellectual Property Organization has 3 points of what we consider as a trade secret. So it is something that has to be commercially valuable because it has to be secret, and that's where its value lies. It's known to a limited number of people. So in your organization or for your clients, that particular piece of information is supposed to be in the hands of limited number of people. So it could be one person, it could be five, but the people who have access to that information has to be limited, and that differs from case to case. So one of the most well-known examples is the formula for Coca-Cola, which is written down and saved in a vault somewhere in Atlanta, Georgia. But Coke operates in a number of countries, so how does it keep that formula a secret? It provides that formula to a number of its different partners, but it keeps control over who has access to that particular formula. Um, the third thing for it to be a trade secret is the secret has to be kept protected through reasonable steps by the rightful holder of the information to be keeping it secret, including using confidentiality agreements within business partners and employees. So in the UAE, that's usually how we protect a certain amount of secrets. So what a trade secret can be is pretty broad. It can be anything from personal information, pricing, client information, or some sort of scientific formula or know-how or traditional knowledge. Traditionally speaking, in the UAE, people use non-disclosure agreements, employment agreements, or some sort of contractual remedy to limit what information is protected. Unlike patent law, there's no requirement for novelty. Anything can be a trade secret. Like I mentioned, it can be computer code, it can be a recipe for some food, pricing, different sorts of things as long as it's kept secret. There's no subject matter restrictions, so patent law does not allow the patenting of anything that's natural or something that's obvious to a person who's skilled in the art. Because nobody outside a limited number of people knows what it is, you really don't have a standard against what is being protected. Again, reasonable steps, they can be different. Can be something as simple as keeping the formula in a safe. If it's in our computer program, it's protected under strict encryption or people having limited access to that information. Under different jurisdictions, you have different standards about how you protect. Like I said, we've used contracts to protect trade secrets, which either can be through non-disclosures or non-competes. The UAE also has competition law and commercial law, so certain practices, especially in the acquisition of trade secrets from one competitor to the other, can be categorized as an unfair trade practice. One thing a trade secret does not protect against is if someone on their own comes up with a similar invention or a similar trade secret. So let's say you have two competing scientists, both are working on a similar formula using known methods. If both of them, let's say one person discovers something in January, the other person discovers it in May, and the person who discovers it in May makes it public, the original person loses its novelty. So they lose the protection because there's no guarantee that that thing would have remained secret or somebody else found out the invention by themselves. So you're always subject to outside constraints, which you may or may not have control over. So this is something I pulled up from the UK EU IPO, and it's the number of litigations related to trade secrets that are happening in Europe. Unfortunately, I was not able to find data for the Middle East, but in total, since last year, there were about 700 lawsuits in Europe that related to trade secrets. And the number of industries were varied. Some were in chemicals, some were in food, some were in FMCG. So there's no one industry that just specifically uses trade secrets. But what I found interesting was that the most number of cases by a lot were happening in Italy for some reason. And other countries that are bigger industrial powerhouses like Germany and France actually had a lot less. France had more than Germany, but there was also a large number of cases happening in places like Belgium, Poland, Romania. So enforcement of trade secrets within Europe, and it helps that Europe has a federal, both a European law, which is then codified in their respective countries. It helps that they have a legislation where if your information leaks out to the public, you have some sort of remedy through statute and then through the courts. So, like I mentioned, the UAE does not have strict federal law that protects trade secrets. So what we do in our practice is we use different laws, both IP, commercial, and criminal, to protect trade secrets. So in the patent law, there are 3 articles that talk about industrial information and know-how. So Article 61 of the federal patent law says that for something to be a trade secret, it has to be kept secret in the sense that it is not, as a body or in the precise configuration assembly of its components, generally known among or readily accessible to persons within the circle that normally has to deal with this kind of information in question. It has to have commercial value because it's secret, and has been subject to reasonable steps by the person lawfully in control thereof to keep it secret. So if you are someone who is in control or is in a management position, you have to take what is reasonable to actually protect that information. There's exemptions for when you have to make a disclosure to the government. So if you're working in pharmaceuticals, you have to apply for a marketing authorization, or if you're working in agriculture and chemicals, similarly, you get a 5-year protection for disclosing that information. So if it becomes available to the public, you have a remedy in that sense. And then again, Article 63 talks about people who are in control of that information. So the reason I wanted to put this out there is because Article 64 talks about acts that are contrary to fair commercial practices, essentially the acquisition of information. So when we're talking about artificial intelligence, we do not know what these large artificial models, like all these models, have been trained on. So it's possible that information that your company or your clients' companies have kept may have been used to train some of these models. Now, the UAE, again, also does not have a federal law that regulates artificial intelligence, but there's a national strategy called the Artificial Intelligence Strategy of 2031, and AI principles that the UAE has adopted. So any development in that sector is taking into account all those principles. So keeping your information protected puts a lot of onus on your IT and security teams, because you need to make sure that that information is not available or easily available. So you need to have better security, you need to have better AI policies, you need to make sure that people who have access to that information is very regulated. So the patent law also distinguishes between what is not an unfair practice. So information that's available publicly, so anything that's available in the public domain, is free for you to train your artificial intelligence systems. Other things we've used in the past, so the UAE Penal Code strictly penalizes unauthorized disclosure of trade secrets for your own benefits. So in India, a couple of years ago, there was a case where a manager in Pepsi got hold of, a manager in Coke got hold of the formula for Coke, whatever their recent formula was, and he tried to sell it off to Pepsi. So Pepsi went to the police, and that person was caught. So similarly over here, the law is broad enough that it doesn't distinguish between whether you're doing something for your personal interest or for commercial value. But if you somehow get access to someone's trade secrets and you're using them for what's your personal benefit, that could be anything monetary or some sort of recognition. laws in the UAE are very broad, so you can still fall under the act. And especially if you're a government servant here, where a lot of things are used, the UAE is very tech savvy, so we have a lot of use of AI in government services. A government servant is subject to 5 years in prison rather than 1. Employment law, like I mentioned, is another aspect. So employees have an obligation to keep industrial and commercial secrets of their employers secret. The commercial law has fines for any disclosure between 50,000 dirhams to, that should be 500,000 dirhams, sorry about that. And we also have the Dubai International Financial Center, which is a big arbitration hub. Contracting parties can subject themselves to the DIFC, where if you have an arbitration clause, you're subject to what's called an offshore law. So you can contract out of the UAE federal laws, but DIFC has its own IP law. So you will be subject to that law in your trade secret dispute. The advantage of having that is only the parties are bound by that law and not everyone else, and whatever reward you get is kept confidential between the two parties. But again, the DIFC law also does not have any particular definition of trade secret. Do you want me to just go? Okay. Other things you can consider, the UAE now has a data privacy law as well. So Natalia, who was talking about the EU GDPR law, the law here is modeled on GDPR as well, and that's another outlet for you to enforce your protection. The data privacy law talks about a clear standing of AI, and as we see more and more case law coming out of it, once we have a national AI law, there's talks about having people have access to their personal information, especially if that personal information was used in the training of artificial intelligence. Other laws, there's the commercial fraud law, the commercial transactions law. So when you don't have one federal law that can apply to you, the best practice we found, at least in our practice, is to comply with different laws in different sectors that may touch upon the subject. I'll talk a little bit about trademarks as well. When Jyoti and I were talking about this section, a bunch of things have actually happened in the news. So I don't know if people saw yesterday, China released their own open source AI model, which is apparently 10 times more efficient than what was available in the market in the US. But again, we don't have access to the information of what training these modules have been based on. So without that information, we don't know if your intellectual property has been used to train some of these models. But if you have an idea, you can use different laws to actually go after these AI tools. The UAE is a signatory to the Paris Convention on Industrial Property. So we've used the Paris Conventions when enforcing trademarks, especially for brand protection cases. But we really haven't tested it when it comes to trade secrets. So while there isn't, like I keep emphasizing, there's no federal law, there's a bunch of other similar laws you can use for enforcement of trade secrets. There's a couple of tips that we usually give clients. If you're using an AI system that's been trained on data that you don't know, make sure you have a human that's overseeing whatever AI process you're doing. The problem is that it's so broad, and the use of the AI varies from industry to industry. Having a human in the loop and not relying solely on AI solely will definitely benefit your company, and make sure that you're not using proprietary information that you may have come across through some illicit means. Conduct IP audits so you can figure out, okay, what actually is a trade secret within your company and what you can use, and then figure out how to protect it. Uh, have updated internal contracts. So if you are using contractual employees, make sure you have a NDA or a non-compete. Non-competes in the UAE are valid for about 2 years, but as we mentioned, some laws talk about indefinite retention of information and disclosing it to competitors. Restrict access, especially if you're protecting data on the internet or using IT services. Make sure you have very strict contracts with your IT providers, especially if you're storing information on the cloud. One day you'll see an update that says, oh, whatever data you're stored, we've been using it to train our AI model. So make sure you are constantly updating and keeping up with the trends that your um, that your service providers are providing you. Um, People use, so in the software field especially, in the UAE you cannot get software patents, but people use a combination of patent protection and trade secrets to keep their information safe. And one of the things is making sure that you don't disclose everything to your different partners. And that is everything. So.
Thank you, Talal, and sorry for being late. The session was preponed and I just got the notice. So I'll bring in a bit of India perspective. India also does not have a clear definition on trade secrets. We interchangeably use the term as trade secret or confidential information. We also do not have a codified law to defend trade secrets, but we do take support from contract law and common law principles as principle of equity or breach of confidence. Generally, there are damages and other things associated with trade secrets, but if it is clubbed with information technology, for example, hacking of a computer or system and all, then there are criminal liabilities starting from penalties to imprisonment. When you approach court for misuse or misappropriation of trade secrets, the court would ask you to first clarify a few criteria. What was the commercial value? Was the information of some commercial significance? What were the steps taken to secure it? To how many people it was known? So to qualify as a trade secret, it has to meet some benchmarks. It has to have some associated commercial value, and you are supposed to take due precautions so that it does not leak out. If the infringer shows that it was openly available to everyone in the company and it was never told as a trade secret or there were no agreements in place, then probably you cannot enforce it as a trade secret. And then to how many people it was known? Was it known only to the scientists who were doing the experiment? Was it known only to the accounts team through which your list of specific partners was there? So to how many people and to what specific set of people the information was available? So all these criteria are looked upon when you go before the court to seek remedy for breach of trade secrets. And of course, we do rely on US and UK judgments while arguing these cases. So coming up with trade secrets in the era of AI. AI is a much talked about topic, and DeepSeek is a new news. I think we'll have some more news coming in, and the social media platforms and news channels would be busy for some time at least with DeepSeek. So Talal, practically, when you work with your clients, what is their take? When they are one is your clients who are using AI in their inventions. One are you as legal professionals using AI in your day-to-day tasks. Practically, how comfortable you feel clients are with the use of AI by lawyers?
So I think it depends on the client. So our patent team has been told by, I think, 90% of our clients to not use any AI. And it's funny because AI as a tool has existed for more than, Google has existed for more than 20 years. So like machine learning platforms have existed. It's generative AI that is very new. So I've seen demos by service providers who they all offer different things. So one was pretty good. Like they have a database of patents available from all over the world, so Japan, US, Canada, and it's a searching tool. It doesn't write anything, it doesn't write any claims, it doesn't do anything. It just searches databases and finds patents that are similar to yours. But in addition to the searching, it'll give an analysis of, okay, this is 50% close to what you have written or 70% close. So in those particular cases, I think AI as a tool can help your legal practice. Other things obviously are a bit more, we have to be more cautious of. So Mona, my colleague, she talked about hallucinations. So we've seen cases in the US and Canada where citations for legal briefs were being used. Our firm, so we use Microsoft Office, so we have a Copilot license. We don't really use it because of the limitation of the license where it's going to start using data that you put in to train the model. I've been told that there are other LLMs available where you can have it segmented to your own server and it'll only train on your data and won't be used to train other data. But at the moment, I'm cautious because especially we deal with clients' proprietary information. So I don't want to take the risk of our information, of a client's information being used to train something and then it coming back to our firm because we keep our standards very high. In terms of clients who are using AI themselves, like I said, it's a spectrum. We have, in Pakistan specifically, we work for a lot of small software houses. They're using AI to code. But like I said, keeping a human in the loop, they're using 15 to 20% uh, uh, of their code that they're using for clients to generate new code, and then someone's coming in to making sure that it's practical, it's working, and they're adding that little bit of a human element. So, but I've heard from bigger companies that are using AI to develop new technologies or within their products. When they seek protection for those particular things, I think the region will have to catch up at some point because as of now, the UAE specifically does not recognize any. It recognizes a legal person as either a company or a person. It doesn't recognize a machine.
So I think this again comes back to the ownership authorship issues that we were discussing yesterday, and we have of course seen the Dabas case, much talked about case so far. So in terms of trademarks, do you see a rise in the clients using AIs to create new trademarks rather than in the traditional ways relying on the human intellect to design new trademarks? And what can be the ownership authorship issues in terms of trademarks designed by AI? The other point, which is like my perspective, is that for trademarks, distinctiveness becomes pretty crucial. So it's not just about being different. Your trademark should stand out. It should be distinct. Now, AI models are trained from open sources, right? Um, so what is the training and how much distinctive trademarks they're able to create? And trademark is not always about registration. You know, if it goes through the registration process, then of course you may get a challenge on distinctiveness and other aspects. But where the applicant chooses not to get it registered, but just to enforce it, to advertise it, to just publicize it and start using it, distinctiveness may be a big issue with the marks being generated by AI because the knowledge, of course, is based on what is available around. So how do you think that can be tackled, or what problems do you see with that? Do you see a possible rise in the court cases because of the distinctiveness and being different issues? How do you look at that as a lawyer?
Yeah, so I think you hit the nail on the head. The problem is all the training that all these modules have done. So when you search for something using, let's say, ChatGPT, for example, it goes through its entire trainings data set and gives you an average of what it thinks you're looking for. So it's not necessarily giving you something unique. It's combining different data sets that it's used to learn and providing you a scale of that information. So in some cases where it's summarizing a lot of information, it might give you a pretty good and distinct summary. But if all of us search for the same thing here, it's possible that it's going to give us widely different results. The problem with generating a trademark similarly is if it comes up with something that's been used, that's training data that's been used beforehand, it'll provide something that's not going to be distinct or unique. The strongest trademarks in law are either combined words or completely made up words. So like Lexus, for instance, for cars, has never been used before. So that's a distinctive word. Pfizer for pharmaceuticals, or a combination of words. So like Coca-Cola, for instance, you have Coca and then Cola, right? So Coke does not have rights for the words cola, but it has rights for the whole word put together within the red color. I think it's going to start creating a branding issue where it's going to start generating trademarks that have similar features to trademarks that are already created. And litigation from there might arise based on the similarity. But then it depends on, so we really haven't seen all the litigation in the US has been on copyright or ownership. So I think there'll be branding issues, but we might see similar issues that people faced in the internet where they would just Google something or find something on the internet and pass it off as their own. So we might see a change in how trademarks are actually examined, where examiners may come back and say, okay, how did you come up with this word? What did you use? Did you use AI? Because we're already starting to see, like in the US, for patent disclosures, they're asking, okay, did you use any AI in creating this invention? Please let us know where it was. So we might see something similar for trademark registration, where an examiner will ask you, okay, did you use AI to create this trademark or create a device or logo? And we have to also consider the fact non-traditional trademarks, so smell trademarks, 3D trademarks, sound trademarks, AI can be used in creating these things. So maybe not traditional word device marks, but in non-traditional trademarks, there could be issues.
Yeah, thanks for bringing in those points, because that's food for thought for me as well. So NDAs plays a huge role, and specifically in terms of trade secrets and IP, what is written in the language of the agreement makes a lot of impact, specifically when you're going to enforce them. Traditionally, what we have seen is that we have a very specific template for NDAs and agreements, which has the basic clauses defining the parties, the law that's going to apply, what are the liabilities and everything. Do you think there is a specific need for AI? I personally feel when I work with entities who are, who are relying heavily on IT infrastructure, or whose employees are working virtually, or who are using some AI tools, to specifically having some dedicated clauses for AI and putting in some restrictive clauses for their employees to maintain the trade secrets, specifically with the use of AI, prohibiting, bringing in some clauses which prohibits use of AI beyond a specific level. And as you said, a human involvement in the AI kind of these. As a lawyer, what's your take? Do you think that it's time that we modify the templates for agreements and bring in the AI element?
No, I think that's a good idea because, again, it depends on what industry you're working in, what kind of level you're working on, and what AI tools you're using. So if you have something that's internal and that's not going to be used to train a bigger model, restricting your employees into using the tools that are provided for them is not onerous. So in the UAE, if restrictive covenants are allowed, But if a contractual term is onerous on a person, then the courts will say that it's invalid. So restricting them to using certain software, certain procedures in the course of business, in my eyes, is very reasonable. But then you also need to make sure outside of the contract that someone is not using open source AI or some other software, or they're not misappropriating all that information. So having a separate clause outside of your warranties makes sense, and you'd rather have a proactive approach than a reactive approach. So you may not need to actually enforce that contract, that contractual term, but having it makes you more certainty. And that's one thing the law, at least in a civil law country, we're looking for more certainty in our contracts.
I've been asked to cut short. So moving towards sorry? Yeah, we can just discuss one more topic, is that so we are seeing issues. So we have seen NY Times suing OpenAI in US. There is a similar case now started in India where ANI has sued ChatGPT, alleging unauthorized access of their content without their permission, saying that this was not freely available and this is used by ChatGPT to train their data. And they quoted certain content which they say is an exact copy of their content. And then, of course, ownership, authorship issues are there. So do you see that it is time to upgrade our legislations and accommodate these kind of aspects, bringing in the AI thing, maybe defining AI properly in our legislations, or maybe making it all the more clear in terms of ownership, authorship issues, whether AI can have the ownership, authorship rights in a specific IP? Because so far what we have seen is the court orders interpreting and defining the existing definitions under the law of inventors and other issues. So do you think that it's time that the policymakers should start thinking of accommodating the law?
I mean, probably, especially because we're seeing more and more adoption. In certain cases, for example, in copyright, we have work for hire. So a court could interpret an AI tool as a work for hire under the control of a human. I had a discussion like 2 years ago with someone where they talked about the patent law, the standard changing from novel, non-obvious to someone who's skilled in the art, to novel, non-obvious to a AI system that's trained in the art. But how would you judge that? We don't know. In terms of the lawsuits, I'm not very hopeful with what those, because the problem is, like, it's the U.S. Supreme Court, and U.S. law allows for fair use, which is copying copyrighted available information unless, and if it's being transformed to something new. So technically that's happening, but there's a profit model. We don't really have fair use the way it's operated or used in Europe and in the US. So if you were to have similar training within the UAE, there's a licensing model available through copyright law. So there's a difference between what the government wants, what public sector wants, and what the technology sector wants. And I don't think that's going to happen. I think we have to wait and see how all these different cases are resolved. Then there might be some harmonization in the legislation, especially because we're in the GCC, we're 6 countries, India, Pakistan are separate, US is separate, Europe is more than 30, 40 countries. Each of them have a different idea, maybe similar, maybe different ideas on what an AI system is actually and how it needs to be regulated. So once we have those case laws, then maybe there could be something within legislation that comes into place. And the other thing is we're a monarchy over here, so the law could change tomorrow, or it could take 10 years to change. So as a practitioner, you have to then read into the law as it is.
I think there is a need to discuss these topics at a larger scale, maybe in terms of treaties and amending the format of the treaties, because even the IP law, whatever harmonization across the globe we see is all emanating from the various international treaties. So I think one of the ways of doing it is to actually bring in these discussions at that level and see, how can we be more futuristic. And why just futuristic? This is just happening around. We are already seeing litigations arising out of use of AI. So to have some scope to accommodate AI somewhere in the IP system. So that's it. I think we'll have to conclude. Thank you, Talal. The other co-panelist was not there, so I had to bombard you with all the questions. Thank you.
Thank you so much. Any questions from the audience? No questions. So now I would like to request Jyoti to honor Talal. One second. Thank you, both of you.